Hi there. Welcome back to Professor Snyder's, that's me, Music Biz News. And here are 10 misconceptions that I have read in various comments and pages throughout social media. And my hopefully factual, but probably opinionated answers to these misconceptions. Number one, there are established laws passed by Congress that regulates AI. False. Congress has not passed any laws regulating AI. As a matter of fact, not only are there no laws, an earlier version of the now passed One Big Beautiful Bill Act, passed in July of this year, would have imposed a 10-year moratorium on state AI regulation. Although this specific provision was removed following significant opposition, mostly in the Senate. And instead of passing any laws about AI, they tried to make it law that not even states could pass laws about AI, and that failed. So now, only the states can pass any kind of regulations on AI, and because there's 50 states, it's all over the board. I'll provide a link to a list of states and their pending AI regulations they have to vote on in the comments below. 2. The government of the United States cares about artists and musicians and is working on laws regulating AI and copyrights. False. First, the tech companies reject any kind of regulations and their lobbyists are very busy. As Washington debates major tech and AI policy changes, big tech's lobbying is relentless. Major players, including Meta, Alphabet, and NVIDIA, combined to pour more than $36 million into their influence operations during the first half of 2025, an average of $320,000 a day. And as for the government itself, the Copyright Office created 3 documents about AI and copyright. Part 1 was named Digital Replicas, which dealt with issues like deepfake. Part 2 was named Copyrightability, that determined what can and cannot be copyrighted. And Part 3 was named Generative AI Training, and it was released May 9th, 2025. And it addresses fair use and AI, and fair use is the center of most all of the lawsuits between media companies and AI, so it's very important, and the tech companies didn't like it. So the very next day, after releasing that preliminary report, Part 3, the person in the Copyright Office, who is a copyright expert and led the creation of the 3 AI guides, was fired. The Register of Copyrights is the principal advisor to Congress on national and international copyright matters, testifying upon request and providing ongoing leadership and impartial expertise on copyright law and policy. Copyright Register Shira Perlmutter was abruptly fired by email by the White House's Deputy Director of Personnel. No one is in charge of the United States Copyright Office since May. During a wild time for copyright law, the U.S. Copyright Office has no one at the helm, and no one knows when that will change, and without a leader actually showing up at work, the Copyright Office is not totally business as usual, but this makes the tech companies very happy. And meanwhile, the European Union has already passed laws regulating AI. Number 3, what is stated in the Copyright Office reports is permanent and binding. Again, false. Guides published by the Copyright Office are not binding. While they provide authoritative information and guidance, they do not have the force of law and are not enforceable by courts. However, courts may consider the interpretations and determinations set forth in these guides as persuasive authority in certain cases, on a case-by-case basis. But even now, there's debate over whether copyright certificates that it's issuing right now could be challenged in the future. Number 4, the law states that only human-created parts of a song can be copyrighted. Any parts generated by AI isn't protected. False. And this came from the second report on AI by the Copyright Office, Part 2, Copyrightability. Generating content with AI is often an initial or intermediate step, and human authorship may be added in the final product. The copyright would extend to the material the human author contributed, but would not extend to the underlying AI-generated content itself. And so one of the applications I talked about in a previous podcast was if somebody had wrote a song and they wrote the lyrics, like Monet, the music created by AI she would be able to copyright just the lyrics, but not the music. But number 5, copyright law states you can't copyright a song if you use AI for any of the parts. And again, this is from the second of the 3 reports. Human actors should be able to claim copyright if they select, coordinate, and arrange AI-generated material in a creative way. This would provide protection for the output as a whole. In other words, the whole song is protected, although not the AI-generated material alone. Which leads to number 6. Music created by only using prompts can't be copyrighted. That's yes and no. And back to part 2. The report concludes that given current generally available technology, prompts alone do not provide sufficient human control to make users of an AI system the authors of the output, because prompts essentially function as instructions that convey unprotectable ideas, and users do not control how the AI system processes them in generating the output. Then it also states, however, the report leaves the door open to a future in which works produced by prompts to AI systems may potentially be copyrightable. And this has already happened when an art piece, a single piece of American cheese, was created by AI autonomously using only prompts. At first it was denied copyright, but then they changed their mind. In August of 2024, copyright was denied because the U.S. Copyright Office said it lacked human authorship necessary to support a copyright claim. After reviewing a detailed step-by-step workflow video demonstrating the artist's creative process while creating the art, the office reversed its decision. The image contained a sufficient amount of human original authorship in the selection, arrangement, and coordination of the AI-generated material to warrant copyright protection. So something that had been created by AI using only prompts was granted copyright protection. So it is possible. Number 7, there are specific guidelines about AI and fair use. False. Not only are the Copyright Office AI reports not binding, the 3rd report concerning fair use, Part 3, Generative AI Training, is only a preliminary report. It was never completed or made official. It probably shouldn't even be used as a guide because a final official report, if ever, might have different conclusions. Number 8, composers will one day be paid if AI is trained on their music. Tiny chance. Record labels want to be paid to license their music to be used to train AI. This would be a negotiated blanket amount, probably in the millions of dollars, and they're asking for similar arrangements they made with streaming services like Spotify and networks like NBC. The major labels licensed their full catalogs to Spotify, but made sure the agreements were on their terms and that they made out just fine no matter what. Spotify paid the majors massive advances with no requirement that any of the money trickled down to their artists. The majors got equity in Spotify, some ownership. And the same thing is happening with UMG and Udio. Collectively around 18%, which is now below 7%, after cashing out shares in the hundreds of millions of dollars. The focus in the last couple of years has been on Spotify and just how little musicians and composers are paid per stream, 0.003 to 0.005 cents. And that's for a complete song. If anything, AI has broken down songs into tiny, tiny bits that are then combined with bits of other songs to create new music. And unlike samples that can be detected on recordings, there still isn't a way to determine where the little bits came from in order to pay the copyright holder. And maybe one day when they can put some kind of copyright markers on these little bits, how much would a royalty be for tiny bits being used to create music when whole songs being streamed brings in almost nothing? The only ones making money from the licenses will be the record labels, who will at most allow royalties of some kind to trickle down maybe to the most popular artist. Number 9, music companies are only looking out for their cherished artist when it comes to AI music. I don't think so. Not when generative AI music market to be worth $3 billion by 2028, says this report, or when the chief digital officer of Universal Music Group says if you don't claim a seat at the dinner table, you might wind up on the menu, record labels adopting AI. 1/3 of the top 10 on Billboard's country digital music charts dated November 15th, is composed of AI-assisted artists. Walk My Walk, contributed to Breaking Rust, has spent its second week at number 1. So the record labels are seeing a whole lot of money floating around there with AI-generated music. AI-generated songs are on the charts, pushing down human songs off the charts. And so there's blood in the water. And the record labels, they want some of that. Sharks are hungry. Number 10, the court's conclusion about the generative AI case of Thaler versus Perlmutter is fixed law. And maybe for now, because it's about the only thing out there. The U.S. Courts of Appeals for the D.C. Circuit issued a significant ruling, March 18, 2025, in the case of Thaler versus Perlmutter, which affirmed that a work generated autonomously by an AI system without a human author is not eligible for copyright protection under current U.S. law. This is existing copyright law. In this judgment, the appellate court stated that the Copyright Act makes no sense if an author is not a human being. In other words, it made use of copyright law that already exists that has no mention of AI or fair use. And they pulled one word out of it, author, and that is what they based their conclusions on. But in its concluding remarks, the appeals court stated that even if the human authorship requirement ever became an obstacle to the creation of original works, it is a policy argument for Congress and not the courts to address. So even the courts are saying, Congress, get off your ass and start working on regulating AI and copyrights to protect creators, musicians, artists, and their intellectual property. We know the tech companies really want you to not do that. They don't want regulations, but you should be addressing this now. I hope you found something interesting in the 10 misconceptions that I listed. If you have any comments, if I butchered the law, because I'm not a lawyer, or anything else, feel free to comment below, and please like and subscribe to my YouTube channel. Thanks.